this law does not have in its terms free IDs. And in fact, it costs money to obtain underlying documentation in order to get the limited number of acceptable IDs. And that was one of the major issues in this case. This is what's known as a stage 2 or more extreme form of voter ID. So it's very different. And in fact, the opinion by Justice Rogensack, the majority opinion, said that it is unconstitutional as written to not have a provision for free IDs in the law. And she's only able to save the law by rewriting the administrative code of the state and telling the DMV that they have to have a mechanism in place to allow people to petition for an ID so that the fees would be waived on the grounds that they can't obtain the underlying documentation without paying money. This is not currently in the law. She has to rewrite the administrative code in order to then save the law and say the law can only be enforced if the DMV does this. Of course, the DMV was not a party to the case, had no say whatsoever in whether or not it could administer this, and this is essentially judicial rewriting of the law. And quite frankly, I find it remarkable. And while I applaud Justice Rogensack's decision for firmly and clearly stating that any sort of fee attached to the right to vote is unconstitutional, under our state constitution and under the federal constitution. That should be a bedrock principle, and I'm glad that she affirmed it. The correct next step is to strike down the law and direct the state legislature try again, not to rewrite the law in some vague way that's simply going to encourage future litigation. But I want to make clear for the listeners, the voter ID law will not be in effect for the fall election.
The thing is that that is going to pose a problem for Judge Edelman's decision is that from what I understand, the U.S. Court of Appeals is bound by what the state Supreme Court defined the law is.
Well, I don't think that's correct, Steve. The law as interpreted by our state Supreme Court in the majority opinion by Justice Rogensack is very clear that there is no explicit provision for waiving fees to obtain the birth certificate, certificate of naturalization, passport, the underlying documents that would be required on the short acceptable list of ID. So the factual finding is actually to the contrary, and moreover, regardless, the federal courts are interpreting the United States Constitution and whether or not the law violates the U.S. Constitution. Using the poll tax as a basis for saying it's unconstitutional, but the majority going on to rewrite the law in order to try and save it, it's an interesting example of sort of judicial activism, in this case by the conservative wing of the court. But I think ultimately it's going to be a bit of a sideshow. I think the real litigation here will be in the Seventh Circuit. And, you know, the difference between this federal litigation and the Supreme Court case, Crawford, of a couple years ago, which dealt with Indiana's law, is there was no factual findings. And the Supreme Court was very clear. There were no factual findings about who was affected. In front of Judge Edelman in Wisconsin, there were explicit factual findings that over 300,000 Wisconsin citizens would not be able to vote under this law. That's a huge factual finding that was not present in front of the Supreme Court, and quite frankly, I think makes all the difference.
Speaker Robin Vos has said that the free ID clause would lead to fraud because it's unclear what the process will be to ensure a person is a legal citizen and who they claim to be. Ed, I want to get your thoughts on Robin Vos's concern about the free ID.
Well, this is the problem, essentially, when a court rewrites a law in order to avoid striking it down, because it's unclear. There's this remarkable couple paragraphs in Justice Rogensack's decision where she says, well, here's what the DMV has to do. And she lays out that there has to be a petition, and the DMV has to consider the petition, and it's unclear whether the DMV is obligated to issue a free ID or whether they have discretion to deny the petition. It's unclear exactly what the procedures are. And so all this does is create confusion and uncertainty, and it's going to create more litigation. And I think Lester Pines, one of the attorneys involved in the case, his first comment was, well, this is just going to keep the ball rolling with litigation because it creates more confusion and uncertainty. That's what happens when judges try to engage in a little legal rewriting of laws. It creates more uncertainty, and that's really not the job of our court. If you find the law as written is imposing a poll tax, is incurring a fee in order to vote, which was a finding, then the next step has to be it's unconstitutional, try again. It's not let me fiddle around with it and see if I can fix it.